Welcome, everyone. Welcome first to the GO committee members from both the Senate and the Assembly. Thank you for being here for today's joint informational hearing. Thank you to all of those who have made themselves available to provide testimony here this afternoon, and certainly welcome and thank you to the public for being here today. This is the first in a series of two scheduled joint informational hearings between the Assembly and the Senate GO committees on the topic of gambling in California. Our next scheduled hearing will be on June 24th, which is titled "The Legality of Internet Poker: How Prepared is California to Regulate It?" The purpose of today's hearing is for committee members of both houses to get an overview of gambling in California relating to the history, legality, authorization, and regulation of the various sectors within this diverse and complex subject area. California has a long history of allowing some forms of legal gambling and a degree of tolerance of illegal gambling. In the 1800s and early 1900s, societal standards and laws relating to gambling tended to change back and forth from prohibition to regulation. Since 1933, much of the basic framework of gaming in California has been enacted by the people through constitutional amendments rather than by the legislature. The state lottery was enacted through a constitutional amendment, as was horse racing, Indian gaming, and charitable gaming. The Constitution specifically prohibits Nevada and New Jersey's type casino gaming on non-tribal lands. Today, California gaming market consists of 60 tribal casinos, 89 commercial card rooms, a state lottery with more than 21,000 lottery retail locations, 4 horse racetracks, and charitable gaming. California's gambling industry has expanded considerably over the past 15 years due to tribal gaming operations, and because of that, generates more revenue than just about any state in the country. It was reported that in 2013, the state's tribal casinos accounted for a fourth of the nation's $28.3 billion in total Indian gaming revenue. Legal gaming as a whole has not just expanded in California, but throughout the country. The various gambling industries employ thousands of Californians and help generate billions in direct and indirect revenue for the state while providing significant benefits to California's economy. Gambling today in California is not the gambling of old. People can legally wager on live horse races over the internet, play Las Vegas-style games on gaming devices at tribal casinos up and down the state. They can purchase a Powerball lottery ticket that includes players from multi-state locations for huge payouts. As technology has evolved, so has the manner in which games are played and marketed to the customer. Throughout all these changes, it is clear that gambling has a major presence in the state and will continue to grow in scope. Plain and simple, gambling in California is big business, but it will only continue to be big business if it is regulated with the highest degree of oversight and integrity. This state's gaming regulatory bodies have a big responsibility, but that does not mean that we should still not demand excellence and accountability. California's gaming sector will only continue to prosper and grow through vigilant and unyielding oversight that is focused squarely on maintaining integrity. However, no regulatory system, whether state or federal, can assure integrity or achieve its purpose by simply enacting laws or making declarations. Regulators must regulate in a professional and effective manner. Today, we are going to hear from the various regulatory bodies that oversee gambling in the state. We will not only learn about the regulatory side of things, but the history of each legalized gaming sector since its inception in California. In addition, I hope we learn about some of the key terms that are associated with each sector, such as exclusivity, Prop 1A, Class 3 gaming, ADW, moratorium, rake, 90-10, and others. I feel that as the chair of this committee, we owe it to ourselves and the citizens of this great state to be better informed on the history, legality, authorization, and regulation of gambling in California before we move forward on any issue which might have long-term impacts on the various gaming industries in the present and in the future. With that, we'll go ahead and begin the informational hearing. If Anita Lee, Senior Fiscal and Policy Analyst with the LAO, would please approach and present your testimony.
familiar faces and new ones as well. Committee staff asked us to prepare a high-level overview of gambling in California. For the purpose of that, you have a handout before you, and our comments are tailored really to be as consistent as possible across the board to allow for comparison amongst the various entities. And our hope is that this information will prove to be helpful as you continue your discussion today and into your next hearing. So if you turn to page 1 of your handout, we first provide a high-level overview of the major forms of gambling. We've got tribal gaming, the California State Lottery, card rooms, horse racing, and gambling by charitable organizations. For each of these, we're really going to try and provide information on the authorizing statute, the games offered, the size of the industry, the revenues that are received by the state, and finally how they're regulated. Turning to page 2 of your handout, we're going to first start with tribal gaming. Proposition 1A, enacted in 2000 by voters, amended the state constitution to allow federally recognized tribes to operate slot machines, lottery games, and banking and percentage card games on tribal lands in California. A tribe can open a casino with these games if the governor and the tribe reach an agreement on a tribal state compact, the legislature approves the compact, and the federal government approves the compact. The legislature currently has ratified tribal state gaming compacts with 73 of California's 110 federally recognized tribes. Of these, 58 currently operate 60 casinos in 26 counties. The industry generates about $7 billion in revenue after winnings. In accordance with the terms of the various tribal state compacts, the State General Fund is projected to receive $330 million in revenue in 2014-15. An additional $30 million in revenue will support state regulatory and problem gaming costs. In terms of regulation, each tribe with a casino maintains a gaming agency to provide primary on-site regulation of gaming operations. The California Gambling Control Commission and the Bureau of Gambling Control within the Department of Justice share responsibility for ensuring that tribes comply with the terms of their tribal state compacts. Turning to page 3 of your handout, we'll now turn our attention to the California State Lottery. As mentioned, Proposition 37, enacted in 1984, amended the state constitution to authorize a statewide lottery in California. Authorized games can provide opportunities to instantly win, such as through scratchers, or win by selecting numbers, such as Super Lotto Plus. Some games, such as Powerball, which was previously mentioned, are multi-state lottery games. Approximately 21,000 retailers in all 58 counties currently sell lottery products. The industry generated roughly $2 billion in revenue after winnings in 2014-15. In terms of state revenue, nearly $1.4 billion in lottery revenue will be used to support education in 2014-15. An additional $700,000 in lottery revenue will be used to support administrative, regulatory, and problem gaming costs. Finally, Proposition 37 also created a 5-member lottery commission to oversee the operations of the lottery. This includes authorization of the various games as well as regulatory activities. Commission members are appointed by the governor and confirmed by the Senate. Turning to page 4 of your handout, we have card rooms. State law permits card rooms to operate in those cities or counties that have adopted ordinances that authorize them. In addition, card rooms also have to comply with additional state regulatory requirements, such as licensing. Currently, there is a moratorium on new card rooms through January 1st, 2020. Moratoriums on new card rooms have generally been in place since 1995. Card rooms offer certain card games, such as poker and Pai Gow, that have been approved by the Bureau of Gambling Control. These games must also comply with state law and local gaming ordinances. Currently, as mentioned, there are 89 card rooms that operate in 32 counties in the state. The industry generates about $850 million in revenue after winnings. In terms of state revenue, card rooms and their owners are subject to state business and income taxes. Additionally, $19.5 million in fees are projected to be collected from the industry to support state regulatory and problem gaming costs in 2014-15. In terms of regulation, the Bureau of Gambling Control and the California Gambling Control Commission share responsibility for regulating the card rooms. This type of regulation includes licensing as well as approval of games and gaming activities, and that typically refers to jackpots and tournaments. Local governments also have limited oversight of the card rooms, which includes the ability to increase the number of gaming tables in their jurisdiction under specified circumstances. Turning to page 5 of your handout, we have horse racing. Proposition 3, enacted in 1933, amended the state constitution to legalize wagering on horse racing. State law authorizes wagering to occur on-site at the track, off-site at satellite facilities in California, online through advanced deposit wagering, or at out-of-state locations that collect wagers on California horse races. Currently, 38 tracks, fairs, and satellite facilities operate in 19 counties in California. The industry generated nearly $660 million in revenue after winnings in 2013-14. Similar to card rooms, the horse racing industry is subject to state business and income tax requirements. The State General Fund also received $1 million in revenue directly in 2013-14. Additionally, $12 million was spent in fees collected from the industry to support state regulatory and administrative costs. Finally, Proposition 3 also created a 7-member horse racing board to oversee and regulate the industry in California. Members of the board are appointed by the governor. Last but not least, we have gambling by charitable organizations, and there are really three types of activities that fall under this category. First, we have card night fundraisers. State law authorizes certain nonprofits to operate one of these card night fundraisers per year. Only specific card games that are approved by the Bureau of Gambling Control, such as poker, may be played at such events. Statute also requires that 90% of the gross revenue from the fundraiser go to the nonprofit organization. These events are regulated by the Bureau of Gambling Control, as well as DOJ's charitable trust section, as well as local ordinances. Second, we have bingo. Proposition 9, enacted in 1976, amended the state constitution to authorize cities and counties to allow bingo games to be conducted for charitable purposes. Additionally, state law authorizes remote caller bingo, which is the live calling of a bingo game broadcasted to multiple locations within the state. A local ordinance must be adopted before bingo or remote caller bingo can be conducted. The Bureau of Gambling Control, the California Gambling Control Commission, and local governments regulate bingo activities. Finally, we have raffles. Proposition 17, enacted in 2000, amended the state constitution to authorize certain nonprofit organizations to conduct raffles to raise funds for beneficial or charitable purposes in the state. The measure requires that at least 90% of gross revenue go to those purposes. Raffles are regulated by DOJ's charitable trusts section. So with that, that's your overview for your hearing today. We're happy to answer any questions, and we hope it was helpful.
Okay.
Hi, Ms. Lee. On page 2, under size of industry, in your report you write that the industry generates about $7 billion in revenue and winnings, and the others you said was annually. Is this annually or just cumulatively since the inception of the 2000 legislation?
This is annually, so it's $7 billion in revenue after winnings. And we would note that in the piece when we talk about state revenues, a number of the industries also make local contributions and payments. It depends on what agreements they have. We also point that out because with tribal gaming, they also make payments into another fund that benefit non-gaming tribes. So if you're curious about other revenues, we would note that as well.
Okay, and then of that, the state receives about $330 million, which is plus another 30, which is about 5% of. Is that in statute the amount that we're supposed to get, or does it incrementally go up each year or every 5 years, or do we renegotiate, or is that in statute that we're stuck at one number?
Sure. So the amount that is deposited into the state general fund, so the $330 million, that is dictated by the tribal state compacts. So whatever is negotiated between the state and the tribe. And so they will differ. Some are based on net win, some are based on the number of machines, et cetera. In terms of the $30 million in revenue for regulatory and problem gaming costs, this comes from a special fund that that tribes will deposit into based on the terms of their tribal state compact. This fund is called the Special Distribution Fund, and it supports other things as well. So in terms of that, the Gambling Control Commission, DOJ's Bureau of Gambling Control, our problem gaming, state problem gaming entities have cost, and they're approved as part of the state budget process.
Okay. Thank you.
Mm-hmm.
Okay, do we have any other questions from members? Seeing none at this time, thank you for your presentation. If folks involved in our second panel would please approach. We have Jennifer Henderson, Deputy Attorney General, Indian Gaming Law Section, Department of Justice, Ronald Diedrich, Deputy Attorney General, Indian Gaming Law Section, Department of Justice, Stacy Luna Baxter, Assistant Bureau Chief with the Gambling Control, Department of Justice, Nathan DeVal, Assistant Bureau Chief, Gambling Control, Department of Justice, Tiffany Conklin with the California Gambling Control Commission, Ron Yeager with the Chairman, United Auburn Indian Community Tribal Gaming Commission, Rick Badaker, Executive Director of the California Horse Racing Board, and Paula Labrie, Acting Director, California State Lottery. Welcome to all of you, and okay, why don't we begin with Jennifer Henderson.
Good afternoon, Chairman and members. Deputy Attorney General Jennifer Henderson with the California Department of Justice, Office of the Attorney General's Indian and Gaming Law Section. As requested, I'll provide a short background of Indian gaming in California. The Federal Indian Gaming Regulatory Act, or IGRA, was enacted in 1988 to provide a statutory basis for the operation of gaming by Indian tribes as a means of promoting tribal economic development, self-sufficiency, and strong tribal governments, and to shield tribal gaming from organized crime and other corrupting influences to ensure that the Indian tribe is the primary beneficiary of the gaming operation. IGRA separates gaming into three categories and provides for different modes of regulation for each category of gaming, consistent with each form's perceived vulnerability to corruption. Class 1 gaming is subject to tribal regulation only, without federal or state participation. Class 1 games are social games solely for prizes of minimal value or traditional forms of Indian gaming engaged in by individuals as a part of or in connection with tribal ceremonies or celebrations. Class 2 gaming is regulated jointly by both federal and tribal authorities without state participation. Class 2 games include bingo and other games similar to bingo. Class 3 gaming includes all forms of gaming that are not Class 1 gaming or Class 2 gaming, such as casino games, slot machines, and lotteries. Only Class 3 gaming requires state and tribal participation through a compact negotiated bilaterally by a tribe and the state, subject to federal approval and limited federal oversight. Under IGRA, a tribal state gaming compact may include provisions relating to subjects that are directly related to the operation of gaming activities. Tribal state compacts in California include provisions regarding the application of state and tribal laws and regulations to the licensing and regulation of the tribal gaming activity, the allocation of criminal and civil jurisdiction between the state and the tribe necessary for the enforcement of the laws and regulations, procedures for the resolution of any dispute between the state and tribe that may arise under the compact, an assessment by the state for the cost necessary to regulate the gaming activity. At the time IGRA was enacted in 1988, California prohibited even the possession of all non-antique slot machines and the play of all banked and percentage card games. California's Constitution also expressly prohibited all lotteries except for the California State Lottery. The California Constitution declared that the legislature has no power to authorize and shall prohibit casinos of the type currently operating in Nevada and New Jersey. In 1998, proponents of tribal gaming sought and received voter approval of Proposition 5. Proposition 5 created a statutory requirement that the state enter into a model tribal state gaming compact with federally recognized tribes to allow certain Class III gaming activities, including banked card games and slot machines. Proposition 5 amended state statutory law, but not the state constitution, and as a result, the California Supreme Court ruled that Proposition 5 was unconstitutional because it conflicted with California's constitutional ban on casino-type gambling. After the Supreme Court ruled on Proposition 5, Governor Davis's office began compact negotiations with California tribes. In September 1999, the state executed substantially identical tribal state gaming compacts, often collectively referred to as the 1999 compacts, with 57 tribes. Eventually, a total of 61 tribes entered into the 1999 compacts. The 1999 compacts were conditioned on the occurrence of several events, including ratification by the California legislature and the passage of Proposition 1A. Proposition 1A was a ballot measure to amend the California Constitution to create an exception for tribal gaming to the constitutional ban on casino-type gambling. The legislature ratified the 1999 compacts effective January 1, 2000, and on March 7, 2000, California voters approved Proposition 1A, which amended the California Constitution. Under the new amendment to the California Constitution, federally recognized tribes in California were permitted to operate slot machines, lottery games, and banked and percentage games pursuant to a compact with the state. Also under the new amendment, the governor is the only state official authorized to negotiate compacts with federally recognized tribes. The constitutional amendment required that all compacts, once negotiated by the governor, must be ratified by the California legislature. Pursuant to IGRA, the federal government must approve tribal state compacts before they are effective. In May 2000, the Secretary of the Interior approved the 1999 compacts, which became effective upon publication in the Federal Register. The term exclusivity, as it is used in the tribal gaming context, is a shorthand term acknowledging that the California Constitution and the compacts negotiated under Section 19F of the Constitution, the Proposition 1A amendment to the Constitution, provide for the tribe's ability to conduct certain forms of gaming that are prohibited to others in the state. All tribal state compacts in California contain provisions that provide the tribes with remedies should the ability to conduct those forms of gaming be extended to others in the future. The 1999 compacts contained two funding provisions that originated in the Proposition 5 Model Compact. The first funding provision is the Revenue Sharing Trust Fund, or the RSTF. Pursuant to the 1999 compact provisions regarding the RSTF, certain California gaming tribes share a portion of their gaming revenue with Indian tribes that either do not engage in Class III gaming at all or do so only on a limited basis. The RSTF is administered by the California Gaming Control Commission. Specifically, the Commission's duties as trustee of the RSTF include the receipt, deposit, and distribution of the RSTF monies. The Commission has no discretion with respect to the use or disbursement of the trust funds, and its sole authority is to serve as a depository of the trust funds and to disperse them on a quarterly basis. The RSTF provides up to $1.1 million per year to each federally recognized tribe in California that did not operate slot machines or operated less than 350 such machines during the year. The amount a tribe is required to contribute to the RSTF depends on the number of gaming device licenses it possesses. The second fund requires a payment to the Special Distribution Fund, or the SDF. This fund is controlled by the California legislature and may provide funds to cover the state's cost of regulating tribal gaming, mitigating the adverse social, economic, and environmental impacts associated with tribal gaming, including problem gaming, to cover shortfalls in the RSTF, and to fund any other similar programs specified by the legislature. The amount a tribe is required to contribute depends upon the number of gaming devices it operated prior to the execution of the compact and its net win per device. Since the initial 1999 compacts, additional tribes have executed tribal state gaming compacts with the state. Today, a total of 58 federally recognized tribes are operating 60 Class III gaming facilities pursuant to a tribal state gaming compact. Currently, a number of tribes are engaged in discussions with the governor's office for the renegotiation of their compacts. I'm happy to answer any questions you may have.
Okay, as a matter, thank you for your testimony. As a matter of housekeeping, we'll finish with the Department of Justice representatives as our first part, and then members, if you go ahead and hold your questions till we get through those first 4 pieces of testimony, then we'll take questions at that time.
Good afternoon, Chairman Gray, committee members. Thank you for the opportunity to allow the Bureau to provide you an overview of our role and responsibilities. My name is Stacy Luna Baxter. I'm the Assistant Bureau Chief with oversight over the licensing and games unit within the Bureau. The Bureau of Gambling Control within the Department of Justice regulates legal gambling activities in California to ensure that gambling is conducted honestly, competitively, and fairly, and free from criminal and corrupt elements. The Bureau, formerly the Division of Gambling Control, was created January 1st, 1998, with the enactment of the Gambling Control Act. The Act established a comprehensive plan for the statewide regulation of legal gambling. It provides a bifurcated regulatory system whereby the Bureau of Gambling Control serves in an investigative role and the California Gambling Control Commission serves in an adjudicatory role. Once fully established in fiscal year 2000-2001, the Bureau had a budget of approximately $13 million and authority for 158 positions. 12 years later, despite its growing span of responsibility due to various budget reductions, in fiscal year 2012-13, the Bureau remained with the same level of position authority. In fiscal year 2013-14, the Bureau's position authority did increase by the 33 positions that were transferred over from the California Gambling Control Commission per the Governor's reorganization plan effective July 1st, 2013. Today, the Bureau is 100% special funded by the Gambling Control Fund as well as the Indian Gaming Special Distribution Fund, for a total budget of $26 million and 191 authorized positions, of which 47 are peace officers. These positions provide the regulatory oversight, compliance, and enforcement of 89 licensed card rooms, 60 tribal casinos, 35 third-party providers of proposition player services, and 34 remote caller bingo organizations. The Gambling Control Act mandates that the Bureau investigate the suitability of individuals who apply for licenses and work permits associated with controlled gambling, monitor the conduct of these licensees, and to investigate violations of the gambling law. Currently, the Bureau addresses these mandates through its 2 main sections, the licensing section and the compliance and enforcement section. The licensing section conducts the background investigations of applicants requesting a registration, license, or work permit for the card room and remote caller bingo industries. In addition, pursuant to the compacts between the California Indian tribes and the Governor of California, a state certification process was established whereby all gaming resource suppliers, financial resources, and tribal key employees that are issued gaming licenses by the various tribal gaming agencies submit an application for a finding of suitability by the Bureau of Gambling Control. The section investigations, which can be extremely sophisticated and long-term, investigate whether the individual is in compliance with the requirements of the Gambling Control Act and is a person of honesty, integrity, and good character. These investigations serve as the basis for suitability determinations by the Gambling Control Commission. The scope of each background investigation varies depending on the particular license type or the type of applicant that they are and the complexity of the applicant's history, but normally includes an in-depth research and analysis of each applicant's background through inquiries of various personal, public, and law enforcement resources. Also, the financial aspect of the business owners and entities are closely examined to verify that all persons in ownership and control interest in that gaming operation do come forward for licensure as required. In addition to the background investigation, the licensing section is also responsible for the intake and processing of all the applications and fees. Based on the last prior 3 fiscal year actuals, the licensing section receives on average per year 6,000 applications. Currently, there are approximately 9,400 active licensees, registrants, or work permits, and approximately another 4,000 pending applications. The review and approval of denial of the third-party provider of proposition player services contracts that are entered into the gambling establishment and third-party entities. We approximately receive 70 initial renewal or amendments of these contracts per year. We also complete the review and approval of all controlled games and gaming activities to ensure they are in compliance with Penal Code 330 and 337J. We receive approximately 400 applications per year for these gaming and gaming activity requests. The review and comment of all proposed local gaming ordinances to ensure their ordinances are within compliance of the Gambling Control Act as required by Business and Professions Code 1996.1. And the Bureau also reviews and provides recommends approval or denial on gaming table increase requests that come through the local jurisdictions and subsequently the individual card rooms. The Bureau reviews these requests to ensure that the requests are based on legal statutes within statute.